This is case number 22-190477. This is Credit Acceptance Corporation versus Brittany Allen. The matter is before the court, set for a status conference, scheduled conference where the court has received an answer regarding this matter. The complaint in this matter alleges damages of $8,913.68. It looks like this is a vehicle purchase and breach of a contract in that regard. Your appearance for plaintiff in this matter, please.
Good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
Thank you, Mr. Warburg. Good morning to you. I'm looking now for Miss Brittany Allen. If you want to assume, please say something at this time, ma'am. Miss Brittany Allen. Right, the record should reflect the court set this matter on. Looks like I've set it for today. I'm going to wait. I'm going to wait a few minutes, counsel. It's 3 after 10, but I'm going to wait a few moments and I'll come right back to this to see if Miss Allen is going to come.
Okay, thank you, Your Honor.
All right, the court now calls case number 22-189895. This is Debt Holdings LLC versus Martinique Allen. The matters before the court, as the matters have become joined by contest. I do see an answer. I see also plaintiff's motion to strike the answer and enter default judgment on the alternative for summary disposition. All right, the court will further, just one moment here.
Would you like our appearances, Your Honor?
Just one moment. Just one. The court would indicate that the claim in this matter is for some $17,193.20. Your appearance for Debt Holdings, please.
Good morning, Your Honor. Hamzi Sob on behalf of Debt Holdings, PA2080.
Thank you. Good morning to you, Mr. Soul. For defendant Martinique Allen, Ms. Allen, if you're on the Zoom or if there's counsel for Ms. Allen, your appearance at this time.
Yes, I'm here.
All right, what's your name, ma'am?
Martinique Allen.
All right, thank you, Ms. Allen, and good morning to you, ma'am. So, counsel, it looks like this arises out of a previous landlord-tenant relationship and a claim of a breach in that regard. Is that correct, counsel?
That's correct, Your Honor. It was a lease agreement, and there was a breach of the lease agreement. And now there's a past due amount that was due and not paid.
All right, got it. And this had to do with residential property or commercial?
This is a commercial property.
All right, got it. All right, so have the parties talked about this in any effort to try and get this resolved? I looked at, I think I looked at something in regard to this matter where there was claims that the property was not in a suitable condition for the operation of the defendant's business, but I also looked at, it seemed that the contract was an arm's length contract where it was the tenant's duty to maintain the premises in such a way that she could operate the business concern. So I know that you filed a motion in this regard. Ms. Allen, did you receive the motion to strike and enter default in this matter, ma'am?
I believe no.
So it looks like I have a timestamp on that of August the 8th. I noticed it seems to me, ma'am, that you're looking at your documents. Do you see a document entitled plaintiff's motion to strike?
No.
Counsel?
Your Honor, we mailed that motion and all the exhibits attached to it to the address that was listed on Ms. Allen's answer, which is the same address. Sorry, Your Honor.
You're talking about the Brush Street address, correct, sir?
Yeah, that's correct. And the same address we also service the summons and complaint.
And on my summons of complaint and even the paperwork that was I received, it doesn't even has my name. It has my name in some of the paperwork of the lease, but it also has, what is, 1 second. It has a Michelle Filter, Fletcher, and it's saying doing business as Hood Books. I have no clue who that is.
Got it.
So I have mixed paperwork. So I don't know.
All right.
And I just have summons of landlord tenant contracts.
All right. So you signed, at some point you signed a lease agreement regarding a particular piece of property where you're gonna operate a business. Is that correct, ma'am?
Yes, in 2013. Was it?
Okay.
2016.
I'm looking through the file now. It looks like that was to be an operation of of a salon, I should say.
Yes, it was a hair salon.
And were you able in fact to operate the business there at some point?
At some point throughout the time, it was a lot of commotion and everything going on back and forth to court. Also by the city of Detroit and stuff. It was so many times that they came out to put violations up, and then every time I contacted the JMC management about everything that was going on, they just referred to me with a letter stating that I have letters that's here also too, stating that the city of Detroit property maintenance division, because of the city just need money and treat the business and loyalty owners as their self. This is what they will respond to me with, of ignoring the city. And I also had the building inspector in 2017 come out because I had roofing problems real bad, and I contacted them over and over about it, from pouring water. I have photos, I have documents and everything about how much I could not even run a hair salon out of that business, out of the building.
All right, so under the contractual agreement, ma'am, was it your obligation to take care of the premises in that regard, roofing and things of that
Only
nature, ma'am?
minor maintenance, not a roof problem.
All right,
Minor maintenance, not a roofing problem.
gotcha. All right, so how long of a period did you sign the lease contract for? Was that year by year, or did you sign a longer period?
It's supposed to have been a year by year, and then December of 2017, she wanted me to sign another one, and I refused to because of all the damages that was to the building and the roofing problem, and I could not operate a salon out of there. So I refused to sign a 2017 lease.
Got you. So when did you exit the property?
It was 2000 and I want to say that, and then let me see. I have my.
Was it in 2017 or 2018 or early?
I would say the beginning, 0518.
0518. All right, got it. Now, how much was the rental obligation per month at the premises?
I'm thinking it might have been like 850 or 775 or something. I'm not for sure. It was a while ago. And then every time that we went to court for rent withholding, I had placed the money into escrow. So they wasn't receiving the money until they fixed the damages on the building. So once they fixed the damages onto the building, the 36th district escrow would release the money to them.
Is the money still in escrow now, or was it released at?
No, it was the last time it was released to me, which was amount of 790.
790.
But other times, once they completed the work, it was released to them. But any other time that they will hold the money into escrow. That's why they wasn't getting paid on time, because I couldn't operate, and the money was being held in escrow.
Thank you. Let me come to you, counsel, in regard to this matter. I'm wondering how the number got to $17,000. This was a year-by-year contract of $850 per month. And then a question attached to that is a question of mitigation or any mitigation efforts in this regard.
Well, your honor, this lease started in 2013. It was re-signed in 2016 and then re-signed again in 2019. So if you look at the exhibits, it was re-signed all the way up until we see a May 11th, 2019.
No, I never signed.
That was the last. That was the last.
Let me stop you, counsel, for just a moment. Now, ma'am, did anybody interrupt you while you were talking?
No, I'm sorry.
Thank you. Go ahead, sir.
So your honor, if this was indeed a question of repairs, and as Ms. Allen noted, money was deposited into escrow and then released. I don't have any knowledge of that. I wasn't on the landlord-tenant matter. What I do know, based on what she tells me, that money was released, so the repairs were done. This remaining balance of 16,152 is what I know on the ledger, and then an updated file of showing 17,193. That's advancement, which is also in the lease agreement, stating that if the tenant fails to pay the rent obligation, then the rent would advance to the end of the lease, and that amount was so at the end there was a $6,026.80 balance before the advancement. After the advancement, there was $9,776.80, and then there was a 18% annual interest rate, which is notated in the lease agreement, that was collecting in 2019, 2020, 2021, and then finally in 2022 when we filed this this complaint, which leads us to the $17,000 balance.
Okay, I got it. Yeah, that's I don't know. All right, so it seems to me that it might be something that the parties need to see if they can find a way to resolve it. But certainly at those numbers, I don't see how you're going to get there. But at this stage, obviously, I have a breakout room where you could try to talk about whether or not you can get it resolved. If not, we'll set it up on the scheduling order for the parties to exchange information. I do see the motion in this matter for somebody in this position. It does seem to me that there are a number of disputes that would sound in factual exchange. So I'm constrained to think that the motion would advance at this point. I guess a preliminary thing is Ms. Allen says that she didn't receive a copy of the motion. So what I'm going to do is I'm going to I'll go ahead and set the motion over for a couple of weeks and I'll give opportunity for her to receive a copy so that I can go ahead and hear the issue on the motion. So, ma'am, the only address that we have in the file is the address on Brush Street. That's the address that the document will be sent to. And council will be sending to you the plaintiff's motion to strike. You would need to be prepared to respond to that, either in writing or come to the hearing and be able to give me a response to why you believe that judgment should not be granted summarily, or that the answer should not be stricken in this manner. So I'm going to direct counsel to send a copy out today to the brush address. If you have another address where they should send it to, then you would want to let me know that now, so that we make sure that you have a copy of this document in time for the next hearing, so that you're able to respond to it. So I'm gonna give maybe I'll set it on about 30 days out, and that way, Madam Ms. Allen, if you want to put something in writing in response, you can do that, or you could make sure that you're prepared to respond to it in some kind of way at the next hearing date. That is the motion. That's where we're going to start. So that date's going to be
October 14th. October 14th. I'm sorry, November. Yes, I'm sorry.
right, November 14th. It's going to be the next hearing date on this matter. I'll set it at 10 o'clock a.m. 11/14/22 at 10 o'clock a.m. You will get a notice in the mail. You will get another notice of that date. But you want to take note of that now. 11/14/22 at 10 o'clock a.m. Council, send that another copy indicated you sent one before to that brush address, and so that Ms. Allen has a maximum amount of time to respond to the document, so that I can hear it on 11/14/22. That's a motion here.
Thank you, Your Honor. And then just for Ms. Allen, our number is located on the pleadings. Give me a call. We're willing to work this out prior to that date.
That's fine. I also wanted to know, because I never signed a lease again after the 2017. I never signed a lease for 1920 at all, because my move out date was.
Well, yeah, we can talk about it more over the phone, and then once you have the motion, you'll understand more with all the exhibits that we have.
Yeah, see if you can get something worked out. Otherwise, I'll look at the motion and try to make some decisions in that regard, and we'll go from there. All right. All the best. I'll see you on the 14th of November.
Thank you, Your Honor. Have a great day.
Court now calls, the court recalls 0477 credit acceptance versus Brittany Allen. Ms. Allen, if you're on this Zoom, please say something at this time. The record should reflect that the court did send a notice to Ms. Allen at the address on the Ross. It is the same address that Ms. Allen sent in an answer. That address, the notice, I should say, was sent on the 2nd of August 2022, and that notice set today's date as the hearing date at 10 o'clock p.m. Counsel, on behalf of your client, you received a notice of that particular this particular hearing. Is that correct, sir?
That is correct, Your Honor.
And again, I reiterate that Ms. Allen, the address that you used to send the notice to is the address that she provided. And that address is on the Wall Street in the city of Detroit. The defendant has failed to appear in regard to this matter. Counsel, your pleasure in that regard, sir.
Your Honor, plaintiff does request for entry of default judgment for defendant's failure to appear.
Given that the defendant has failed to appear upon due notice, the court will find that the defendant is in default on failure to appear in this matter. Accordingly, the court will sign an order entering judgment by that default upon presentment to the court. Counsel, you may present your proposal to the court by way of email if you wish to do so. And I'll give you the email address at this time. That is Latifa, LATIFAH.Hunter at 36districtcourt.org. That's 36districtcourt.org, 36th. That's Latifa.Hunter at 36th, 36districtcourt.org.
So, Your Honor, just to confirm, Latifa.Hunter, HUNTER at 36districtcourt.org.
That's correct.
Great. We will submit the default judgment. Thank you, Your Honor.
Thank you, Counsel. Good day to you.
You too.